Good day and welcome to this edition of the GIS Report. For the Office of the Deputy Governor, I am Communications Officer Colleen Penn. The Eastern Caribbean Supreme Court commenced the 2015 to 2016 law year with a ceremonial opening on Thursday, September 17th. To mark the opening, simultaneous special sittings in all 9 member states and territories of the Organization of the Eastern Caribbean States were held. In the Virgin Islands, the proceedings commenced with a church service at the Apostolic Faith Church in Road Town. Reverend Michael Anthony led out the service and delivered a special message to commence the new law year. His message was titled, Being at Peace with Our Decision.
As you, my dear listeners, embark on this law year, the importance of being at peace with all the decisions made, no matter what facet of the judiciary you represent, will continue to be one of the most important assets as we move forward in what is definitely an uncertain future. In Philippians 4, verses 6 to 7, we find the words, "Be anxious for nothing, but in everything, by prayer and supplication, with thanksgiving, let your requests be made known unto God. And the peace of God, which passeth all understanding, shall keep your hearts and minds through Christ Jesus." So I bless you with the peace of God and his wisdom, and may you find the inner strength to do that which you have been called to do this year in particular. And may the Lord ever be with you in all that you do as you uphold the standard of justice in our beautiful land. Thank God.
A procession of the judiciary, magistracy, and Bar Association members from the Apostolic Faith Church to the Supreme Court on Pickering Street took place immediately following the church service. A guard of honor was inspected by His Excellency the Governor, Mr. John S. Duncan, OBE, and Resident Judge, Her Ladyship, the Honorable Madam Justice Vicky Ann Ellis, at the Supreme Court. The special sitting commenced immediately after. Addresses from the bar were given by the Attorney General, Honorable Baba Aziz, Member of the Inner Bar, Mr. Paul Dennis QC, and Ms. Tiffany Scatliff on behalf of the Director of Public Prosecutions. Senior Magistrate Ms. Tamia Richards and the newly elected President of the Bar Association, Ms. Jacqueline Daly, also delivered remarks. The Chief Justice opening address, which is considered the main event, was broadcasted live from Grenada to the other member states and territories of the Organization of the Eastern Caribbean States by Her Ladyship, the Honorable Chief Justice, Dame Janice M. Pereira, DBE. In her remarks, she urged the legal profession to uphold the integrity of the judiciary. During the hour-long address, Honorable Pereira stressed the need for a holistic approach to safeguard the individual and institutional independence of the judiciary. She stated that the existence of an independent, effective, and competent legal profession is a key element in safeguarding and promoting the independence of justice.
This is significant because the role played by the legal profession is critical to the proper functioning of the justice system. Whether the wheels of justice move along a smooth and effective pace, or they grind as if along a gravel path, depends to a considerable extent on how well the legal practitioner performs his or her role in the conduct and pursuit of the causes before the court.
Dame Pereira said that the service of the legal profession to the society is very critical and important, but over the years, it has come under much scrutiny and criticism.
Unfortunately, over the years, the legal profession has come under much scrutiny and I dare say much criticism. Much distrust has developed among members of the citizenry, not only within our member states and territories, but also within the wider region and even beyond. Disbarments, suspensions, and other sanctions against members of the legal profession are becoming all too commonplace. This begs the question, what happened along the way?
The Chief Justice outlined the roles and responsibilities of the legal practitioner in safeguarding the rule of law and highlighted the nobility of the profession.
For centuries, the legal profession has been regarded as a learned and noble profession, possibly the noblest of all professions. This honor was bestowed on the profession not by chance, but because it was well deserved. From time immemorial, members of the legal profession were highly revered, as their contribution to the upkeep and maintenance of the society was a critical one. Lawyers were proverbially coined the movers and shakers of society, trusted counselors, upright citizens, and above all, beyond reproach. There is no mistaking the exceptionality of this calling to stand at the bar, breathing life into laws which are integral to the preservation of order in society by measuring them against our constitutions, developing the common law and statutes, and in the process defending the rights of the citizens of a country justly. However, somewhere along the way, this acuity became compromised or perceptibly derailed and carried with it the great price of public mistrust. Instead, the more common perception is that lawyers are untrustworthy, that they act irresponsibly, and are often seen as persons consumed in arrogance and driven only by greed. As a member of this profession, it is very disheartening to me that lawyers have become more of an object of mistrust rather than reverence. The profession has, in the eyes of many, become a mere necessary evil rather than the impetus for the maintenance of social stability, equilibrium, and order. While some of us may argue that the veracity of this is debatable, it must be conceded that a perception is probably not. The view widely held by many within our societies is that while the learning may be there, that the nobility, in many respects, has long since dissipated.
Dame Pereira outlined the many facets of being a lawyer.
A lawyer is an activist for justice, an officer of the court, a client's advocate, and a member of an ancient, honorable, and learned profession. As such, a lawyer's primary role is one of service in all of these capacities. Lawyers are the link between the litigants and the courts. They are the mouthpiece of the litigants in court and consequently have a great responsibility to ensure that their client's voice is heard through the proper stating of their case within the ambit of the law. This is their duty to the client. The judiciary, too, is reliant on the lawyer to use the principles of the law to advance their client's case so that justice can be dispensed fairly and efficiently. This is their duty to the court. Lawyers should also be courteous to the other members of the profession, always exercising good faith. This is their duty to their colleagues. The proper execution of these duties goes a long way towards safeguarding the rule of law and thus promoting the fair and efficient administration of justice. There is no doubt that in the legal field, quality service and an efficient justice system are intrinsically linked.
The Chief Justice also spoke of the need to preserve the respectability and seriousness of doing the business of justice.
Unfortunately, one of the disturbing issues which currently plague the profession is the lack of respect displayed by some and I emphasize some attorneys at law. An attorney at law must exude and encourage respect for the courts, judges, clients, and colleagues. This respect is very broad and extends to a number of areas of the profession. It extends to how one presents him or herself visually as well as to the audio senses. This, in my view, has nothing to do with passing fashions, but rather with the maintenance of the dignity and nobility of the profession and preserving the respectability and seriousness of the important business of doing justice. Much of what I'm about to say hereafter does not relate to a large number of the legal profession. However, we are all aware of the ease with which all members of the legal profession are painted with one broad brush, so that the failings of the few impact adversely on the many. Over time, one has seen a slow but certain creeping in of mannerisms and expressions which detract from the nobility of the profession and which neither enhances the legal cause of the client nor assists with the proper determination of it. Enshrined in the Code of Ethics governing the practice of lawyers is a requirement that an attorney at law must at all times treat litigants and other attorneys at law with fairness and courtesy. In the same vein, an attorney at law must also encourage respect for the courts and the judges. Part of this duty is to maintain a respectful attitude towards the court and not engage in conduct which is degrading or discourteous to the court. Such conduct weakens rather than promotes the fair administration of justice and does much to destroy public confidence in the judiciary as an institution. Another cause for concern is the lack of adequate preparation for matters before the court shown by some lawyers, notwithstanding advance notice of hearings. Being unprepared is disrespectful to the court, your colleagues, and your client, all of whom are depending on your assistance in the proper advancement of the cause before the court. Therefore, as part of the duty owed to the court and the client, counsel must always ensure that they are fully prepared. By now it is common knowledge that the court frowns on requests for adjournments, particularly when made on the morning of a hearing. In fact, in some jurisdictions, so serious is the issue of an adjournment that counsel runs the risk of serious sanctions for contempt. It is a discourteous practice which cannot be allowed to infiltrate our system any further. It must be the rare and exceptional circumstance rather than the norm. It behoves me to also speak about punctuality. An attorney at law is expected to be punctual in attendance before the court. It is highly discourteous for a litigant or an attorney at law to have the court waiting. The court is often expected to accept excuses, such as, "I was before another judge." This expectation is unfounded and ought not to be tolerated. The court cannot be blamed or expected to wait for or accommodate an attorney at law who fails or refuses to practice in a manner which ensures punctuality before the court. Lateness in appearance also reflects a lack of respect for the court, the client, and colleagues. That said, I would also add that it behoves judicial officers to lead by example. Persistent lateness adds up over time to wasted time and resources, leading to delays and backlogs in the system. The saving of time and resources and the preparedness and competent conduct of matters advances the court's process. It is the failure in this regard which brings the judicial system into disrepute. Also of great concern has been the issue of the misuse of clients' funds or other property. Great responsibility is placed on an attorney at law who has been put in charge of clients' funds. It is very disconcerting that in an overwhelming number of cases, these funds are inappropriately managed by attorneys at law. The court will show no tolerance for such behavior. In many of our member states, disciplinary committees have been established to whom litigants can lodge complaints against an attorney. Such indiscretions can be very costly to the client and quite damaging to the attorney, not only financially, but also professionally. Our neighboring islands of Barbados and Jamaica have of late shown zero tolerance for such behaviors, and we have seen cases of disbarment. In our jurisdiction as well, we have seen a few cases of attorneys being struck off the roll. I will not say much more on this in this forum, except to say that attorneys should always remember and view the duties which they owe to their clients and to the profession as sacrosanct and uphold them at all times.
Dame Pereira applauded attorneys who have demonstrated exemplary performance and conducted themselves in a respectful manner while contributing immensely to the jurisdiction of the region.
There are many attorneys whose performance has been exemplary. I applaud you for your efforts in conducting yourselves in the manner which is required and respected of you. While there are few members of the profession who may conduct themselves in a manner contrary to the ethics of the profession, there are far more distinguished men and women in the profession who uphold the integrity of the profession and who have contributed and continue to contribute immensely to the jurisdiction of this region. I urge you to be responsible for your other colleagues as you strive together to uphold the integrity of the profession.
The Chief Justice provided comprehensive updates on all projects and initiatives over the past year, including the family, commercial, civil, and criminal divisions of the court, updates on access to justice, the use of technology, the jury process, and training were also provided. The commercial court in the Virgin Islands was singled out as having a model court in many effects, and a replica is set to be created in St. Lucia. The government's purchase of digital court recording systems for use by the magistracy was highlighted, and the e-filing pilot project initiative in the Virgin Islands received special mention. At the end of the address, the Chief Justice extended final words to OECS citizens.
To you, the citizens of the OECS, I express my thanks for your support and faith in the legal system. I know that sometimes it is difficult, but I want to assure you that we give our best to ensure that justice is dispensed without favor or bias to any man, no matter what his stature in life, race, or creed. So I encourage you to keep the faith in the judicial system. We remain steadfast to our commitment to you, the citizens of this region, and to serving you with distinction.
The special sitting in the Virgin Islands was presided over by Her Ladyship, the Honorable Madam Justice Vicky Ann Ellis.
On the last occasion that I had the privilege to address you, I pointed out that if the justice system is to be all that it can be, all stakeholders must examine all aspects of what we do. We must make adjustments which may be necessary in order to ensure that we are absolutely at the top of our game. And I trust that incremental strides have been made in each sector. The legal profession generally operates as a fraternity. I would urge you all to recall this and to take whatever small steps you can to strengthen the ties which exist, purely because you all chose to practice law here. Justice cannot be served where attorneys do not speak to each other, do not take each other's phone calls, do not respond to correspondence in a civil manner or at all. And it is in fact hampered when colleagues cannot rely on commitments made and where trust is breached. And when the lack of civility and outright disrespect is witnessed by your clients and the public, it demeans the profession and it brings the entire justice system into disrepute. We trust that the new president of the bar and her executive will take the necessary steps to foster that sense of fraternity.
Government officials in attendance were His Excellency the Governor, Mr. John S. Duncan, Premier of the Virgin Islands, Dr. the Honorable D. Orlando Smith, OBE, and Mrs. Lorna Smith, OBE, Minister for Health and Social Development, Honorable Ronnie Skelton, and Member of the House of Assembly, Dr. the Honorable Hubert O'Neill. Permanent Secretary in the Office of the Deputy Governor, Mr. David Archer, was also present. The Eastern Caribbean Supreme Court was established in 1967 by the West Indies Associate States Supreme Court Order No. 223 of 1967. Its functions are to interpret and apply the laws of the various member states of the OECS, to decide cases of both civil and criminal matters, and to hear appeals. Its mission is to serve the OECS member states by providing access to a system of justice that is accountable, independent, and administered by officers in a prompt, fair, and efficient manner. The OECS is a 9-member grouping comprised by Antigua and Barbuda, the Commonwealth of Dominica, Grenada, Montserrat, St. Kitts and Nevis, St. Lucia, and St. Vincent and the Grenadines. Anguilla and the British Virgin Islands are associate members of the OECS. Thank you for tuning in to this GIS report, where we covered the special sitting of the Supreme Court to mark the opening of the 2015-2016 law year. Reporting for the Office of the Deputy Governor, I am Communications Officer Colleen Penn.